Tuesday, January 6th, and a meeting to discuss the Raise the Age and Youthful Offender Committee bill that is hopefully in its final stages. And I guess I'm going to ask Eric to start a walkthrough of the bill. And I have Judge Zone and Jennifer Pullman here, and maybe some others will join us to offer thoughts on certain sections. If you would start, Eric, can you?
Yes.
And I think you probably need to share the screen.
Yes, that sounds good. Thank you, Senator Sears. Yeah, this is Eric Fitzpatrick for the record with the Office of Legislative Counsel. Going to go over the changes to the Senate Judiciary Committee bill on juvenile proceedings. I'll start sharing my screen now so that the committee can see where the changes were between the draft that we looked at last time and the new revised draft. The changes will be highlighted in yellow as they were last time so that you'll be able to pick them out and spot them pretty quickly as we look at them. But by way of background, you'll notice that the changes are not, there certainly aren't as many as there were in the previous draft, so it should proceed fairly quickly. And I'm at this point, Senator Sears, I probably would just review the changes. Does that make sense to you?
Yes, unless there's some particular area the committee would like to go back over.
Right.
And maybe just go over briefly the headlines, pause the juvenile jurisdiction expansion. That's a
Right.
1-year pause, and then go to the next heading and any changes in any of those headings.
Okay, sure, will do. That makes sense. As you mentioned, the first one is the pause of juvenile jurisdiction expansion. This is the 1-year pause in the implementation of the Raise the Age initiative so that instead of taking effect on July 1st, 2022, it will take effect on July 1st, 2023. And that's when 19-year-olds would be treated as juveniles in the family division for certain offenses. Moving on to the second topic is victims' compensation and restitution in juvenile proceedings. That's making sure that the victims' comp program has the information that they need in order to verify requests for compensation and to identify the fact that the applicant is a victim. The next topic you may recall is the rights of victims in juvenile and youthful offender proceedings. One of the big things going on here is to make consistent the rights of victims in youthful offender proceedings and juvenile proceedings involving listed crimes. I think since they've been worked on, at different times over the years, sometimes language gets added at different points in the legislative process. There were pieces that weren't consistent with each other, so this is making those things consistent. Also, providing that victims get a notification of conditions of release in these sorts of proceedings in all cases without any conditions attached, so they would get notice of conditions of release when the juvenile is subject to them. This is within that there's the information from the law enforcement agency that is also provided to the victim. That's based on an existing statute, Title 13 for adult offenders. The addition of the victim's right to have a victim's advocate present during the course of the juvenile or youthful offender proceeding. So that's a new provision, Section 9. So that sums up what's going on in this area of the bill as well. It's lengthy because there's a number of different places where these same changes have to be made, the ones I'm identifying, but it's all just.
Eric?
Yeah.
I just was thinking, so we've got a section in here that now governs the victim's ability to speak about underlying events and then inability to speak about what happens at the hearing.
Mm-hmm.
But if they're allowed to bring a victim's advocate, what about the victim's advocate? So let's say they choose their sister to come with them. Is the sister governed in any way by what she can say about the proceeding?
I would say no, that refers only to the victim, not the victim's advocate. So the victim's advocate would still be subject to the general confidentiality provisions.
Okay, so the victim's advocate is prohibited from speaking about the hearing.
Correct.
Okay.
Doesn't the victim's advocate refer to the position of victim's advocate that's within each state's attorney's office? And not necessarily any supportive folks that might come? Or might,
I thought they could choose their advocate.
Yeah, I'm going to defer to Jennifer Pullman or someone else on that question. I don't know the answer to that.
maybe Judge Zone or Jen would be willing to offer a thought on that, if they know.
Hi, Tom Zone, Chief Superior Judge.
Yes,
Good
Judge.
morning.
Morning.
So if you look under, one of the ideas here, as I understand it, is to make this consistent with Title 13. Title 13, for instance, under victims' rights in section 5306, mentions specifically the title of called victims advocates, and it talks about how the state's attorneys are able to hire victims advocates. And so I will tell you that when I looked at 5127, I believed that it intended to have the formal victims advocate that is hired by each state's attorney's office, and not someone who is there as a support person for any victims.
Okay,
Yeah.
Thank you, Judge.
That's helpful clarification. Hopefully is that your reading too, Jen?
Yes, we had talked briefly about whether it be a victim's advocate plus a support person. And through that process, we, as I recall, honed it down to a victim's advocate. And my recollection was that was exactly what Judge Zone had indicated.
Okay.
Thank you.
Could you go to page 13 right at the top, Eric?
Sure.
Number 5, I hadn't really stuck out at me. But given our discussions about the availability of residential placements yesterday, children are moved frequently, particularly, in this COVID age where a kid may be at See-All program down in Bennington, may be moved to the hospital, either for a COVID or a mental health reason, maybe then moved to somewhere else. I'm wondering, DCF never mentioned this, but maybe we could put a star on that to just check with them. Because you would be notifying victims, a lot. Particularly during this pandemic, the movement is really, I'm just aware of it because I still maintain contact with the folks at 204 Depot, who used to work for me and I used to work with. So kids are moving around dramatically right now.
Yeah, so we can
I
note
think we
that.
ought to at least ask DCF if there's any concern about that. I mean, I can see the victim becoming very confused, and maybe it should be notified by the agency for any, community-based. I don't know what I just think it would be really difficult right now. Jen, do you have any thoughts?
Yes, thank you, Mr. Chair. I think the intention behind that was when it's a release into the community, not that the victim would be notified. I think it's more so that the victim can prepare for what that might look like.
Right.
And if that is helpful, certainly it's not to ask DCF to be doing that level of work.
I think it should be when the child is released into the community. That might make more sense at this point. I think if I were a victim, my concern would be, am I going to see this guy in school. Not that he's been moved from 204 Depot to the hospital, then back to 204 Depot, and then over to who knows what, Turtle Rock, just for example.
Yeah, we can certainly make that change. I will note that that is existing law in both what you're looking at now is the language for non-listed crimes. For listed crimes and youthful offender, so again, this is part of the making the provisions consistent. So for example, if you look at youthful offender, the existing law, line 6 and 7, already provides that there would be notification. It's upon request, but before the youth is released from a residential facility. So again,
Yeah.
the distinction.
I get, maybe we just flag it for DCF and ask if they have any concerns.
Okay.
And if they do, we could always do an amendment on the floor to express the idea that it should be, released into the community. I think that's more of a concern.
Right. So shall I shoot them an email perhaps?
Yeah, I would. I was hoping they'd be here this morning, but I understand they're busy. But I would suggest that we keep in mind that the goal is to notify when they're released in. So if kid A is in a residential facility and it's gone to 3 different residential facilities, the real concern would be the child ends up in a foster home or some other community program where they might be, you might see them in the community, might see them in school. I think that was the goal of the language.
All right, that sounds good. I'll follow up with DCF and see if they have any thoughts on that.
If they don't, that's fine, and we'll leave it as is. But I kind of noticed it yesterday, given our conversation at noontime with the institutions and health and welfare yesterday. And then it struck me. So please go ahead, Eric.
Yeah, sure. So where were we here? As
I
Senator
think
Booth,
we're at the public safety, unless there were other questions about victims' rights.
well, that does bring us to as you mentioned, Senator Sears, the portion of the bill related to the public safety requirement in both juvenile and youthful offender cases. And this is where there are some changes between this draft and the previous draft. And it's also where you had suggested yesterday, Senator Sears, that would be helpful to discuss for a couple of minutes the individualized nature of these determinations and how they, based on the particular facts and circumstances of each individual case, so that it allows that case-by-case review and determination by the court. And in both instances, both for youthful offenders and youths in juvenile proceedings, you'll see that the public safety requirement, at least now as proposed.
Let me just listen. Yeah, okay. No, I turned it on and then I kind of lost you. So.
Hope somebody's not muted.
Yeah, Jen, I think.
Yeah, I'm really sorry. I apologize.
No problem. No problem. No problem.
All right. Happens to all of us.
Yeah.
You'll see here, we're looking at the youthful offender provision first, that as we mentioned and discussed yesterday, that the existing statute, this is lines 14 to 16, requires that the court first make a determination on public safety before it then turns to the issue of whether or not the youth will be treated as a youthful offender. So as a preliminary matter, it has to make a finding on whether public safety will be protected. Now, the issue with the existing statute was that the term public safety was not further defined. There wasn't any additional statutory guidance for the court to consider when it's deciding that issue. And that's what the proposal is, to add in this section of the bill, to essentially provide some detail and some factors that the court should consider when it's reaching this determination on whether public safety will be protected. And that sort of ties into this notion of an individualized determination, because these facts are all quite specific to the particular youth and the particular offense that is before the court requesting youthful offender treatment. And each of these will vary and be, tied, to the particular case that the court's considering, not a generalized statement about youths or cases generally. So you'll see there's some changes here, but that general statement is still true, that these are the factors that the court's meant to consider. And you'll see that the first change on lines 2 to 3 is something that was discussed yesterday, that the concern was that the use of the term available information might be read as permitting any information to be considered, even information that was not admitted in court when in a proceeding that's subject to the rules of evidence. So to clarify that, the court is permitted to consider, required to consider on the basis of the evidence admitted. So all of these factors, but it's still going to be based on whatever evidence is before the court in connection with the proceeding. So you'll see all of these factors are very
Alice.
fact specific.
Alice, you had a question?
Yes, I'm just wondering who gathers all this information and gives it to the court?
I think the parties will generally be presenting this information. For example, the whoever's making the motion has the burden of proof to show that the youth is, that public safety will be protected, and that the youth is appropriate for youthful offender treatment. So it's going to be incumbent upon that party, whoever it is, to present information to support it. And these are the factors that, if you're the party making the motion, you're going to want to present evidence and all this stuff. And if you're opposed to the motion, then you'll want to present evidence that counters that argument on the basis of the factors as well.
So basically it's the state's attorney and the youth lawyer. Would that seem to be the case? I mean, because
I think that describes it.
might not be
Yes.
involved at this point.
I'm sorry, I didn't hear that, Senator Netka.
DCF might not be involved at this point.
Yes, I think that's right. They're not a party anyway, I think,
Right.
as the commissioner mentioned yesterday.
Okay.
So you see, it's a pretty lengthy list of information and factors that the court is meant to consider. And in factor number 4, there had read the nature of the charge, and we're adding the nature and circumstances of the charge. There had been discussion about, for example, whether or not it's a type of incident that's, perhaps only involves property damage, it doesn't involve any kind of physical harm, or maybe it's something that's maybe, an example of sort of typical youthful behavior rather than something more serious, anything that would involve the particular circumstances of the charge, which again ties the consideration of the whole matter completely to the individual circumstances of the case. So that expands it. So it's not just the nature of the charge, which is what type of charge it is, but also the circumstances surrounding it. No change to the other factors, B through F. You'll see mental health treatment, substance abuse, residential housing status, employment and educational situation, whether the youth has complied with conditions of release. Again, all going into this
Eric,
individual. Yeah.
I think it was Evan yesterday was asking about whether firearms should be expanded into deadly weapons as well. In other words, including knives and things like that. Mr. Chair?
Yep,
Uh,
I think he did.
I would be in favor of adding and deadly weapons on line 18.
I would be also.
Sounds good. I'm noting that change right now.
Does that, what do you think of that, Dick?
I'm fine with that.
Okay.
Is everybody else?
Yes.
Yeah, as long as it prefaces it by saying the history of violence and history of illegal or violent conduct.
Yeah,
with it, so that if somebody has had knives because they're out hunting, that isn't violent or illegal conduct with that knife.
right.
And on that same subdivision, subdivision J, you'll see the word history is added a second time, and that's because Evan had also mentioned that one could conceivably have read the sentence before as being only violence involving firearms, that it wasn't about the youth's history of violence generally. So I think by adding the second word, the second instance of the word history, you make that clear, that it's the youth's history of violence generally and history of illegal or violent conduct involving firearms or deadly weapons is what we'll add.
Yeah.
And the other thing I hadn't mentioned, but you see above that in line 11, is that the youth's criminal record is another one that Evan had mentioned, possibly adding. And so that's added there as well. So that also would be considered during this determination of whether or not public safety would be protected.
Mhm.
So moving on from there, unless there's other questions, this is actually a very much related issue anyway. So that's one proceeding. We're talking about, in that instance, those factors are considered with respect to the determination of public safety when there's been a motion for youthful offender treatment. There's another proceeding involving transfer from family division of the Superior Court that also specifies that public safety be considered. And this was added in the version of the bill you looked at last time. But this language is highlighted here because although there's no changes in it, this goes to the point that Senator Sears was making, to be clear about what proceeding is happening here and how the individualized particular nature of the issue before the court really involves, the particular youth that's the subject of the proceeding. And this is existing law, and that just clarifies, sometimes, as I think the committee knows, we don't always include existing law in a bill if there's no changes, but sometimes we do if it's helpful for context to sort of understand what's really going on. And after I re-looked at it last night, it seemed to make sense to actually include this language as it provides context for what it is you're talking about. I'm just going to skip ahead for a second. When you get to these public safety factors, it's not, in a sense, it might have been, the reader might not be as aware of, what type of proceeding that these public safety factors are being considered in. So it made some sense to put in the language, even though there's no change being made, to describe what this hearing is. Plus it goes to Senator Sears' point about these individual fact-specific hearings. So you see what's going on with these transfers from the family division to the criminal division is that, and the committee talked about this yesterday as well, that in other words, this involves situations primarily in lines, say, 4 through 6. If you've got a child that's 16, 17, or 18, and it's a felony, see, that's line 6, it's a felony not specified in subdivisions 1 to 12. So in other words, it's a felony, but it's not one of the big 12. So because it's not one of the big 12, it's has to be filed initially as a juvenile proceeding in the family division. Remember that whole distinction is that Big 12 has to start in the criminal division. Non-Big 12 has to start in the family division. But there's this provision in existing law that provides for the transfer of these non-Big 12 felonies back to the criminal division, depending on the particular circumstances of the individual case. So in other words, if it's one that the state's attorney, you see, because the motion is made, you look at lines 1 to 2, after the petition has been filed alleging delinquency. So in other words, you're in the family division, delinquency petition is filed, state's attorney has the ability to file a motion to transfer up to the criminal division, even though it's not a Big 12, because of the particular factors that we're going to get to. So again,
Eric?
the list. Yes, sorry, go ahead.
Excuse me, Peggy. Joe Benning is trying to get in and can't. I don't know if Peggy, are you on?
I'm here now. Thank you.
Oh, okay, Joe.
Morning,
Sorry, go ahead, Eric.
Yeah, sure.
Joe. Eric, I want to make sure I fully understand. If a child, why do I keep telling it? my internet connection's unstable again. If a child had attained 12 years of age, but not 14 at the time so a child at 12 could be charged in adult court, correct? Is that what I'm hearing? If they committed a big 12.
Yes, that's right.
And is that something that we're even prepared to do?
Mr. Chair, what do you mean by we?
I mean by where would you put the child?
Oh, I see what you mean.
Understand a 16-year-old could go, I'm fine with all the 16 to 19, because I think that really is an important factor. It's something DCF been asking for and all of us have been looking at. And it's feasible that the 4 beds at Rutland, for example, could be used for that group. My concern is, the reality is if you're 12 to 14 years, and I'm not sure why it isn't 16 years, by the way, where would DCF put the child? Or where would corrections put the child? Yes, because they'd be dealt with in adult court, correct?
Yeah, that's the possibility. Yep.
Do we often charge 12-year-olds in adult criminal court? I mean,
No,
they're-
way back
12?
when those, yeah, well, let me finish.
oh yeah, I
I'll
know.
try to
the
answer your
famous-
question.
Yeah,
There was a case where I think he was 13 or 14, murdered his cousin. And he was dealt with in adult court, but held at Woodside until I believe he turned 18. I can be corrected on those facts of that case. But, so yes, it has occurred. But I have no problem. I'm just concerned about that second part of this.
Yeah, that's been existing law for many years, so it probably would be a good question
It
for
has?
DCF. Yes, so that's
Yeah, I
not,
think
it's
it's-
all existing law.
Oh, okay. Yeah,
I
all
would,
right.
I would be up for changing that. Maybe now isn't the time to do it
Right.
with this bill, but if we put it on our agenda for later, I agree with Jeanette. 12 is kind of shocking to think of that 12-year-old going through family court and being in the custody of corrections. But we don't have any testimony on it as of now, so.
Yeah, I think it's something maybe we should, if it's current, it's the current law, and
Mhm.
so it's what's available right now. So if taking to the 16 to 19 years of age, the claim that there was nothing they could do with the kid, if they're charged with a felony, they can be treated and they can petition to go up to the criminal division.
That's right, exactly, and this
State's
is the
attorney
process.
can petition. So a
Yeah.
kid who didn't commit kidnapping, there was a case in Bennington where the judge said that the elements of kidnapping and one other charge that part of the Big 12 were not there. And so he dismissed those. There were other felony charges that could have been brought, but so the state's attorney could bring other felony charges. They could move to have it transferred, but it's up to the court to decide. Is my correct reading there?
Yes, that's exactly right. And the court and the decision, again, this goes to the discussion we were just having in the youthful offender context, it is up to the court to decide. It's a very individualized, particular decision based on the facts of the particular case. You'll see line 17 that you're looking at right there. The court's got to consider, among other things, whether public safety and the interest of the community would not be served. And again, the proposal here is to, and this is the factors that the court is meant to consider. And again, this is existing law. If it's not underlined, it's existing law. But some provisions have been added here to try and make this public safety consideration consistent with the one that you're proposing to add to the youthful offender context. Again, so that the factors that the court's considering are very individualized, very particular, and also are consistent between, between the two types of proceedings. So again, this language should be familiar since we were just looking at it with respect to the youthful offender statute. But you see line 8, for example, nature and circumstances of the alleged offense, including, and then there's the existing law. All these other factors are very similar to what the youthful offender ones are. Some of these ones are identical, lines 8 through 10. It looks like we have a typo there. I think there needs to be a renumbering. But again, adding the youth criminal record in subdivision 11 to the consideration of these subsequent criminal or delinquent behavior. And again, we'll make the same change here. I think Senator Baruch, you were mentioning, this is where line 5, to be consistent, youth's history of violence and history of illegal or violent conduct involving firearms or other deadly weapons.
Yeah.
I want to make sure I'm fully understanding this, Eric. DCF in the beginning asked for the ability to, if for certain kids, they were concerned about the raise the age, and it goes back to the governor's veto message in S-107. I believe that this addresses that concern so that in individualized cases, the state's attorney can bring the case in criminal division rather than the family division. And I, even though most of it is current law, sometimes it seems that folks lose sight of current law when something grabs a headline. So, for example, a DUI fatal is a felony.
Yeah, if it's a felony, it would be subject to this existing law that permits the motion to be made to transfer to the criminal division.
Right. All of the. Okay, I'm not going to go any further there, but I just, even if over the years, I've become increasingly frustrated when I hear from people who should know better that the law is deficient in this area or that area. And then you look at the current law and the ability is still there to do things. It's just, I guess, want to make it easier to convince the court to do it.
So there just needs to be that change there too, on 12.
Yes.
And is it being, Eric, are you wording it involving firearms and deadly weapons, or involving deadly weapons total? And leaving out the word firearms.
It's up to the committee. What I had jotted down was history of illegal or violent conduct involving firearms or other deadly weapons.
I think or involving firearms and or other deadly weapons or other deadly weapons is the right way. I think we should keep firearms in there because you can make certain threats with a firearm that you might not, just a visual of having a firearm put on your living room table and tell you that you might not want to do something. Whereas other weapons might not give you that same message.
And I'll also do some renumbering there, obviously. We don't need two 11s.
Are you sure?
Yeah.
It's not
avoids
like
13.
elevator. Maybe you were trying to avoid the elevator 13.
Yeah, that's right.
No 13th floor on this hotel.
Right. Is
Okay.
everyone ready to move to the
Yeah.
next section, or?
Yep.
Yes.
Now, this is the issue that this is a new provision in the bill. This was not in the version you looked at yesterday. And you remember, this is the idea, and I won't let Judge Zone speak to this as well, but you recall it's in here because originally DCF had requested that because of the existing legal requirement that in youthful offender proceedings, the youth has to complete a risk and need screening. And now that's current law. They're required to complete that screening, and their YO treatment could be denied if they don't participate. But the request that DCF had made is that that the court be the party that notifies the youth of the fact that they have to complete this screening. So Judge Zone agreed that that made sense. And so this language is an attempt to cover that issue and make clear that you see that the existing law, lines 13 to 14 that struck through, just says the youth shall be offered a risk and need screening. It doesn't say the who should make the offer. And so this specifies that. It says within 15 days, the court shall notify the youth of the need for completion. Again, the existing law, lines 15 through 17 remains, which is that it's actually conducted by the department or a community provider. And then you also proposals to add at the end of the subdivision that the notice specifically has to inform the youth that that the YO treatment could be denied if they fail to participate in this risk and need screening. So the idea is that the court provides the notice, and the notice itself lets the YO know that if they don't do it, then they could have their petition denied.
So can I just ask a question about line 14?
Sure.
The court shall notify the youth of the need for completion. I mean, it doesn't seem like that's clear enough in giving that notice to a youth. Shouldn't the bottom part where it says of the youth is required if you're going to participate in the youthful offender treatment program, because the youth of the need, someone says, oh, okay, the needs, screw that.
Right.
I think that should be more clarity there of what will happen if you don't do it.
Yes, that's a good point, Senator Nick. I think you're right. It would read better if it said shall notify the youth that they are required to complete.
Right.
Is everyone otherwise okay with that
Yeah.
provision for now?
Yep.
Yes.
All righty, then there's just some renumbering, and the only other changes to that piece. Psychosexual evaluation, you recall no changes to this piece. This is the provision that permits the court to order a psychosexual evaluation in juvenile and youthful offender proceedings if the youth is charged with one of these enumerated offenses. And the last change is in the reporting provision. And this has to do with the piece. Remember, originally the report involved specifically secure placements and transitional housing. And then in the draft you looked at last time, it was expanded to also include a progress report on the implementation of Raise the Age. This is subdivision 2, line 6 through 8. And so the proposal here is to just keep it at that. So just say part of this report has to be a progress report on the implementation of the Raise the Age initiative that's under this bill is proposed to pause by 1 year. So the intent is that it would take effect on July 1st, 2023, and just strike the language as to whether or not implementation by that is feasible. So it's just straightforward progress report on the steps being made to comply with the July 1st, 2023 implementation date.
Okay.
Senator Sears,
Yes,
may I go back to the requirement for the psychosocial, whatever that
psychosexual.
evaluation? Yeah.
Go ahead. Yeah,
I might have misunderstood Marshall yesterday when he was talking about that, and the way I heard it was that isn't an individualized test, that's kind of an actuarial predictor, as opposed to the Yahtzee, which is an individualized test. And so I might have misunderstood him, but I thought that he was saying that this was not particularly a good test.
Could I jump in and clarify?
Yeah,
Yeah,
oh,
please.
please, thank you.
It was the other way around. The
Oh,
psychosexual is an individualized psychological assessment. The Yahtzee and tests like that are actuarial tests.
oh, okay. Thank you, thank you.
thank you, Marshall. Is that helpful, Senator?
Yes, I completely got that wrong, so thank you.
Any other comments, questions about the bill?
Can I ask one more question with regard to the part that we were changing it, the language in that paragraph, Eric, that I had asked about?
Yep.
The firearms?
Not the firearms part, but that the notice shall inform the youth that treatment. I'm on line 18 there. The notice shall inform the youthful offender that treatment may be denied. I'm not, in other words, I thought shouldn't it be will be denied if the youth fails to participate? In other words, is it mandatory that you have this test if you're going to get into youthful offender or not? Or are there ways for other people to get in who don't take the test?
Maybe
Well,
Marshall or, go ahead, Eric.
Well, I'm just going to say, if you look at the next subdivision 2, that's existing law. They'll say that has to be completed before the status hearing is held, and that says that the court may extend the period for the risk and need screening for good cause shown. But if it doesn't do that, then the family division, it does say shall, line 2, rejects the case if the youth doesn't complete it within 15 days. So I guess it sort of depends how you read the extension provision. But I suppose overall, it's true that at some point in time that participation is mandatory.
Okay, but is that clear other than you go down to the next couple of paragraphs there? I mean, it seems like if you, either you.
Is it, well, the may there seems to me like it could be somebody misses the deadline, they go back to court, apologize and say they really want to do it. Would it be in the state's interest to deny them then? So I read the may as giving the judge discretion if they don't do it or they don't do it right away, that they could still do it. Marshall is not sure if, is that how you read it?
I would say that what you're describing is practice, which is that there is always a Yahtzee. If the youth shows up and has failed to do the Yahtzee, it doesn't necessarily mean they're getting their petition denied. They may instead just be given another opportunity to do the Yahtzee. And that's been particularly true because in the absence of this provision explaining who has to provide notice of the Yahtzee, it's been done differently around the state. And there's been plenty of situations where youth have shown up to court and it turns out they hadn't even been notified of their Yahtzee, so that or that they've been notified, and due to the pandemic, there have been interruptions in delivering the Yahtzee. So it happens pretty commonly that kids have not done the Yazi the first time and are given another chance. And that's how I read the May, is just sort of a reflection of that practice.
Okay,
I think somebody new could misinterpret it, but if it works, it works. I mean, I don't mind them having a chance to get and making sure that they do, but it just seems like it should be clear that at some point it has to be done in order to get into the program. I don't care when. Fine. If it works, it works. Yes.
If it works, it works. If there are any questions about that on the floor, Senator, I'll yield to you to let
Just-
them know that if it works, it works.
In fact, all the hard questions will go to Alice.
I appreciate, actually, I do appreciate, because I think too often we assume what goes on, and there may be times when that may be, somebody could take that to mean that it won't be denied.
Right. I mean, I like things to be clear, but
Doesn't matter if I do it or don't do it.
yeah,
What's the problem?
that's the
What's
problem.
the big whoop-de, as to quote a mother of one of my clients years ago, what's the big whoop-de-doo? Even though he broke into that store. Yeah.
So that's the walkthrough that I have. I could,
No,
Take
I
the-
think that's very
take the
good.
screen down.
I'd entertain a motion to report. What do we do with the committee bill, Eric? I've forgotten now.
well, it's gonna have to be introduced, but you do vote on it first and then it gets I think it's on notice for, maybe it's, I can never remember. if it's
Yeah, it
notice
goes,
for 2
goes-
days.
No, it goes directly to the floor as a committee bill. It gets introduced and the very next day it's on for second reading. It
Is there
doesn't come
anybody
back
who-
to the committee.
okay, right. Thank you, Senator Baruth.
I would move that we report draft 3.1 favorably to the full Senate.
Is there any discussion? And anyone in the room who would like to make a point or has some issue that they'd like to raise? Okay. Hearing no discussion, Peggy, could you please call the roll?
Yes, and I don't have the form in front of me, so I'm guessing on the order here, so I hope this is
Don't
okay.
worry about it.
Okay, Senator White,
Yes.
Senator Benning,
Yes.
Senator Nika,
Yes.
Senator Baruth,
Yes,
Senator Sears.
Yes, and I want to thank all the witnesses, thank particularly Eric Fitzpatrick and Peggy for the hard work on this over this fall. And Eric, fantastic job. And I think it addresses many of the issues that have been raised by the administration and others about raise the age, and at the same time protecting what's working for 99% of the kids and allowing for that 1% to have different outcomes. I do appreciate it. I thank you very much, all of you. for
Can I
your
ask-
work on this.
Is the effective date on passage or is it July 1?
I believe it's on passage.
Yes, it is on passage.
Thanks.
Peggy, and I'm not gonna, I don't know who to blame, so I'll take the blame myself. Tomorrow morning, we have scheduled S-127. And
Yep.
all of the witnesses that are scheduled would be the same people who I would invite to take up S-183, which is the midpoint probation review, which is what I intended to have for the agenda. Could you, I think most of the people are here, except Matt Valerio, but Marshall's here. Could you inform all of them, as well as the corrections department, that the bill that we're taking up is the midpoint review and not 127, the pilot project?
Yep, I will do that.
I think I may have given you the wrong number
I think,
but
I think I might have guessed on the number and then you didn't correct me. So I think we can both take the blame.
Well, it doesn't matter. Luckily, we caught it before tomorrow morning.
Yep.
I'd hate to have everybody, and Eric, luckily Eric is the draft person for both bills, so
Yep.
put a
I will
different
fix
hat
that.
on, Eric,
Yes.
and tomorrow morning.
Now it's on, I remember you were discussing start time. Is that 9 a.m. tomorrow now?
Would everybody rather do 9?
Yes.
Yes,
don't care
it'll be
at all.
9. 9.
Change it to
We
9.
should be able to knock that off in 2 hours.
Okay.
But the Department of Corrections is not here, so please let them know, Peggy.
Yep, I will. I'll let everybody know.
Thank you. And so, yeah. That's the one where we had, anyway.
One last thing, just to jump in, but on this one, this has got to go to the editors, the juvenile proceedings bill. So
Yep.
we'll just want to give the committee the heads up on that. So they know there's,
Okay.
when it comes back from them, I'll let Peggy know.
Yep.
And Senator Sears, actually, that procedure is, I'll let you know as well, because then you'll have to send an email. I'll CC you on it. So just reply to the email so they know that, kind of the way you used to do with a committee bill, you'd sign it, but we're not there right now. So.
Yeah.
Right. Okay, good.
It's kind of strange. You had to send to editing, but then you're going to send it back to editing, I believe, right?
Yes,
Yeah.
exactly.
So it's kind of strange, but so I'll wait for the clean version from you, Eric,
Yes, thank you.
to post. Yep.
All right. Well, great work, committee. I think we, it's an important bill. And hopefully I know that DCF will be looking for a couple of changes, but that's what always happens in this process. We'll see where it goes. Senator White.
So I just want to say that when the governor vetoed S-107, it was related to this. This was his main concern. So we have reintroduced S-107 as what S-175, but instead of it giving specific dates in there for when the juvenile age increases, it just refers back to this statute.
Oh, good.
I think Eric and Tucker maybe worked on that together, but I'm not sure. But anyway, it doesn't have specific dates in it like the other one did.
All right. Well, great. We're back at 10:30, I believe. So we've got an extra 15 minutes here. We got a whole